Ms. Gretzky?
We are here in two cases of State of Ohio versus Christopher Hallman, case number 25-CR-751 and 25-CR-997. These are two separate cases. We originally set this morning for a suppression hearing, which the state is ready to go forward if necessary. However, the state has made an offer to resolve both cases. That offer being a plea to the indictment in case number 25-CR-751, one count of aggravated possession of drugs, felony of the 5th degree, and a plea in case number 25-CR-997 to count 2, discharge of a firearm on or near prohibited premises, felony of the 3rd degree, with an amended firearm specification Code Section 2941.145, which would remove the language that the defendant had previously been convicted or pled guilty to a firearm specification, which would make it a mandatory 3-year firearm specification. Defendant's present in the courtroom, represented by Mr. Hinton. All discovery has been provided to defense counsel. It's my understanding at this point the defendant wishes to accept the offer. Additionally, the state has agreed to recommend a 5-year prison sentence for a resolution of both cases.
Well, my understanding was a joint recommendation.
Correct.
Yes, it's a joint recommendation.
Mr. Hinton, then, is state's recitation here accurate regarding the discussions you've had with her in attempts to resolve this matter?
Yes, Your Honor.
Thank you. Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here at this time?
Yes, sir.
She indicated to the court she believes that your desire to withdraw your previous inter pleas of not guilty in each of these cases, and in case 25-751, plead guilty to the indictment, which is in felony 5, aggravated possession of drugs, the forfeiture specification, and in case 25-CR-997, you are going to be pleading guilty to count 2 with an amended firearm specification of 3 years instead of the 4.5. The other counts will get dismissed. We will proceed straight to sentencing, where a joint recommendation is being presented to the court that an overall prison term between both cases of 5 years be imposed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you, if at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to speak with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on with both cases, all right?
Yes, sir.
And when I ask you these questions, especially when I'm talking about your rights, they apply to both cases. I'm only going to go over them one time, but both the rights I'm telling you apply to both cases. If anything applies to one case and not the other, I'll make sure I point that out. But otherwise, and I don't think that's the case, but otherwise everything applies to both cases, all right?
Yep.
All right. Give me 1 second. All right, let's get started then. How old are you, sir?
42.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you would have received a copy of the indictment in each of these two cases previously. That's the documents that set forth the charges in each of these cases. Do you remember getting that at some point for each case?
Yes.
And at some point, did you have the opportunity to review those indictments?
Yes.
All right, in regards to the first case, 25-CR-751, you're charged with 1 count. What's alleged here and what you're admitting to is on or about May 14, 2025 in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance, and the amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 of this case?
Yes, Your Honor.
Any questions about it?
No.
Now, the charge also carries with it what we call a forfeiture specification that alleges that during the commission of the offense you possessed or had an interest in property that was considered to be contraband. Contraband is property that is illegal to possess just because of the nature of the property. In this case, it's alleged that contraband is the methamphetamine. The purpose of this is that you forfeit any interest or ownership you have in that property. It doesn't increase the potential penalty you face. It just allows the state to be able to dispose of the property. Any questions about it?
No.
Now, in case 25 CR 997, you're charged with 6 counts. You're pleading guilty to one of those counts, count 2. And what's alleged here in count 2 and what you're admitting to is on or about June 10th, 2025 in Eastlake, Lake County, Ohio, that you did discharge a firearm upon or over a public road or highway, and that conduct created a substantial risk of physical harm to any person or caused a serious physical harm to property. That conduct constitutes the offense of discharge of a firearm on or near prohibited premises. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, Your
Any
Honor.
questions about it?
No.
So which one's he pleading to here? The second one amended?
Yes.
Specification.
Excuse me.
Now there's 2 firearm specifications that are a part of this count as charged. You're not pleading to either of those as charged. You're pleading to an amended firearm specification. It's the second one pursuant to 2941.145. And what you're going to be pleading to is that you had a firearm on or about your person or under your control while you committed the offense that I just read to you, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm, or used it to facilitate the offense. So that's the firearm specification you would be pleading to, which will require a 3-year mandatory prison term, and I'll explain that more in detail in a second. The firearm specification itself, as charged, further alleges that you had previously pled guilty to a firearm specification in another case. That's being dismissed or deleted or amended from that language. If that was in there, the firearm specification would require a 54-month prison term of 4.5 years. By deleting that language or amending that, it reduces it to 3-year firearm specification. So that's what you're going to be pleading guilty to. You understand the difference between what you're charged with and what you're actually going to be pleading guilty to?
Yes, Your Honor.
Any questions about that?
No.
And the first specification will be dismissed as well as all the other counts in the indictment. Is that your understanding as well?
Yes, Your
Do you have
Honor.
any questions about any of those other charges?
No.
Well, then before I can accept your guilty plea to the charges and specification that I just read to you, I need to make sure, again, you understand all the rights you are giving up. And you, first of all, have a right in each of these cases to have a trial. A trial could be to me as a judge, where I listen to the evidence and I make the ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. That ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of these charges. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial and a jury trial?
Yes.
Now, if we did have a jury trial, or any trial, even a trial of the bench, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge. You understand that?
Yes.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty or presumed innocent of all these charges. And the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means It's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that, the state would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. He would be allowed to ask them anything he wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. I'm not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right?
Yes.
Now, you'd also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else can force you or make you. Nobody can compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Lastly, if we were to go to trial and you would be found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues that you raised or could have raised up until this point. And that specifically applies to the suppression motions that you have filed. In each of these cases, your attorney has filed a suppression motion, which he is requesting. He's alleging that your constitutional rights were violated in some manner, and that as a result of that, certain evidence should be prohibited. The state should be prohibited from presenting certain evidence at any trial that was obtained in violation of your rights. And we have a hearing scheduled this morning on the one case to address that, and we have a hearing scheduled on another case, on the other case at a future day, to address those issues. With the plea of guilty here today, you're withdrawing those motions, meaning you're not going to be challenging that issue, and you give up and waive any right you have to challenge it down the road. By pleading guilty, you've given that issue up. You understand that? And we're not going to argue about that or raise that. You're not permitted to raise that later. Do you understand that?
Yes.
And that's what you want to do. Is that correct?
Yes.
All right. Well, do you understand all these rights I've just discussed with you? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Now, do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, in regards to case 25 CR 751, that's the drug case. That charges a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in the range of 6 to 12. Do you understand that?
Yes.
Now, in case 25 CR 997, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if a prison sentence is imposed, which it will have to be in this particular case, I'm going to select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'll be the number of months in prison that you have to serve for this case. You understand that?
Yes.
Now, this case also carries with it that amended firearm specification. That firearm specification, as amended, will require the court to impose a mandatory prison term of 3 years, which must be served prior to and consecutive to any other prison sentence that gets imposed in this case. Do you understand that?
Yes.
Consecutive means at one after another. So you serve 3 years first, and once that's completed, then you'll serve whatever the prison terms are that are imposed by the court on the other counts. Do you understand that?
Yes.
Now, do you have any other charges pending against you anywhere?
No, not to my knowledge.
I understand you're on post-release control when this happened?
Yeah.
Any other supervision, probation anywhere? Or?
No.
I need to advise you that when a person commits a new felony while on post-release control, the court who is sentencing you on the new felony, in this case it's me, has the discretion to terminate or end your period of post-release control and impose an additional prison term of either 12 months or the amount of time you have left on post-release control, whichever is greater. How much more time do you have left on PRC?
I'm not sure.
Okay. Well, if it's more than 12 months, then we would figure that out. That's what I was, and I don't have to do this, but I have the discretion to do this, and I need to make sure you understand that. But you can be sentenced to the greater of 12 months or the amount of time you have left on PRC. And that if that happened, that would have to be consecutive to any other prison sentence imposed for the charges or specifications. You understand that?
Yes.
All right.
Your Honor, I do have a number that I believe is left on PRC.
What is that?
695 days.
That's left?
Yes.
So I could sentence you to an additional 695 days in prison, which would have to be consecutive to whatever prison sentence is imposed. Again, I'm not required to do that, but I do have the authority to do that. You understand that?
Yes.
Thank you. Now, this is not, I didn't look, it's not an offense of violence?
No, it isn't.
Okay. If a prison sentence is imposed, well, let me stop for 1 second. I want to make sure you understand. I'm required to make sure you understand the maximum sentence you face. So in this particular case, the maximum sentence you face, if I imposed the maximum sentence for the discharge would be 3 years, and that would have to be consecutive to 3 years for the firearm specification, so it would be a 6-year prison term that could be imposed in this case. You understand that?
Yes.
And then I do have the discretion to run the prison term imposed in this case concurrent or consecutive to the drug case in 751. So both cases together, you're looking at a maximum possible prison term with the charges you're pleading to of 7 years. You understand that?
Yes.
Plus the possibility of the PRC violation that I explained to you. Any questions about any of that?
No.
All right. Now, upon your release from prison in either of these cases, you could be placed on post-release control for these cases. It's not mandatory. It's up to the parole authority to decide that. If you are, it could be up to 2 years. That's the maximum. And if you are on post-release control and you ever violated any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the prison terms I've just explained, there's other sanctions that could be imposed. You could be fined in each of these cases. In the drug case, 751, there's a possible fine of up to $2,500. And the discharging of a firearm case, there's a possible fine of up to $10,000. $10,000. So together with both cases, a maximum possible fine of $12,500. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
The drug case also could include a 5-year driver's license suspension. Do you understand that?
Yes.
or up to 5 years. Also, in regards to the forfeiture specification that I explained earlier, any right you have to the property in the specification will be forfeited. Do you understand that?
Yeah.
All right, now a few moments ago I explained on the shooting case, the 997 case, that you are facing a mandatory prison term. What that means is that prison must be imposed and you're not eligible for probation or community control sanctions in that case. Do you understand that?
Yes, Your Honor.
Now in the other case, 751, you're technically eligible for community control sanctions. But before I can impose that or order that, a pre-sentence investigation has to be completed. You're not requesting a pre-sentence report in this case. You're wanting to go straight to sentencing. And you're waiving a pre-sentence report, which means I cannot consider probation in that case. Do you understand that?
Yes.
So you understand a prison term will be imposed.
Yes.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want, anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say, whatever anyone says, quite frankly, regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
Very well, then. Do you understand all the possible penalties you face by pleading guilty here today?
Yes.
Any questions for me?
No.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss both of these cases with your lawyer, have him review the reports with you, discuss whatever issues there may be, to answer whatever questions you have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty? I understand the state has made a promise that they're going to recommend a certain sentence and they're required to live up to that promise. But has anyone made a promise to you that I'm going along with that?
No.
Have you been threatened or coerced in any way to plead guilty to any of these charges?
No.
Are you entering this plea freely and voluntarily?
Yes.
All right, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with the plea of guilty?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show in each of these cases. We'll do one case at a time. I want you to listen to her because I have some questions for you about that, all right?
Yes.
All right. So let's start with the drug case 751, Mr. Gretzky.
Case number 25CR751, the defendant on May 14th of 2025 in Mentor Lake County, Ohio, was driving a vehicle when a Mentor police officer conducted a traffic stop. The vehicle was eventually searched, and the officer found white powder substance on the driver's seat. The defendant stated he believed it to be cocaine. It was sent to the Lake County Crime Lab and was found to be methamphetamine, a Schedule II controlled substance. The amount did not equal or exceed the bulk amount.
Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes the facts would show in 25 CR 751 if we went to trial?
Yes.
And what, if anything, did it say about those facts as she presented them? Are they true? Did you do as she said?
Yes.
Very well, then, regarding count one with the forfeiture specification, charging you with aggravated possession of drugs, a felony of the 5th degree. What is your plea to that count?
Guilty.
All right, let's move on to the next case, 25 CR 997, please.
And in case number 25CR997, the evidence would show that the defendant, Christopher Hallman, on June 10th, 2025, in Eastlake, Lake County, Ohio, was following a vehicle on Stevens Boulevard when that vehicle made a turn onto East 354th Street from Stevens Boulevard. The defendant discharged his firearm over the public roadway of Stevens and East 345th. The bullet struck the back of that vehicle where the back window meets the frame of the trunk. The discharge of that firearm created a substantial risk of physical harm to any person or serious physical harm to the property. and the defendant, Christopher Hallman, had a firearm on or about his person that he used to facilitate that offense.
Mr. Hallman, were you able to hear what the prosecutor had to say regarding what she believes the facts would show in this case if we did have a trial?
Yes.
And what, if anything, do you have to say about these facts as she presented them? Are they true? Did you do what she said?
Yeah.
Very well. Regarding count 2, charging with discharging of a firearm on or near prohibited premises, a felony of the third degree with the amended firearms 3-year firearm specification. What is your plea to both of those?
Guilty.
All right, I have in my possession at this time 2 documents. Each are called written plea of guilty and judgment entry, and each of them set forth everything I've just explained to you about your rights and the possible penalties you face in each respective case. Before I can accept your plea, I need to make sure you understand what's in the document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review these documents with your lawyer. Is that correct?
Yes.
Mr. Hinton, is that accurate? Did you review these with Mr. Hallman, go over them with him, answer his questions?
Your Honor, Mr. Hallman read those, and then I had an opportunity to answer any questions he had.
Is that correct, sir?
Yes.
You read the document?
Yes.
You understand what it says?
Yes.
Do you have any questions for me about either of them?
No.
It also appears in each of these documents that you signed each of them. Did you in fact sign each document?
Yes.
And Mr. Hinton, did you witness those signatures?
Yes, Your Honor.
You as well, Ms. Zagretzky?
Yes, I did.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. Find the defendant guilty in 25 CR 751 of count 1, aggravated possession of drugs. The drugs being methamphetamine, Schedule 2, controlled substance, a felony of the 5th degree, in violation of 29-25-11 of the revised code with the forfeiture specification. As for case 25 CR 997, I'll accept the defendant's plea and find the defendant guilty of count 2, discharging a firearm on or near prohibited premises, a felony of the 3rd degree, in violation of 2923.162A3, along with amended second firearm specification. The first one's being dismissed. The second one was amended pursuant to 2941.145. The remaining counts and specifications in this case will be dismissed. Mr. Hinton, in regards to, I guess both of these cases, but particularly 751, you're waiving the preparation of a pre-sentence report.
Yes, Your Honor.
Can I see counsel for 1 second? Everything at brief recess here.
All rise.
All right. We had taken a brief recess prior to going forward with sentencing to allow the state to attempt to contact the victim. My understanding is that you did reach the victim. Is that correct, Ms. Zagretsky?
Yes, Your Honor.
And what did he indicate regarding a victim impact statement and any potential restitution order?
He stated that he would waive any right to make a victim impact statement. He is not seeking any restitution. He's aware he has the right to be here today, does not want to be here, and is okay with the court proceeding to sentencing today.
Okay, thank you. Well, with that said, Mr. Hinton, is there any reason not to proceed to sentencing at this time on your behalf?
No reason not to proceed, Your Honor.
Is there anything then you'd like to say on behalf of your client? We're going to sentence him on both cases at this time, so this will
Certainly,
be in
Your
regards
Honor.
to both cases.
Thank you. I would indicate that, as the court knows, in this regard as it relates to both cases, there is a joint recommendation of 5 years in prison, 3 of those years being mandatory. I know that both sides put a lot of thought into the resolution of this case and that joint recommendation. While we understand the court does not have to join in that recommendation or sentence according to that recommendation, we would ask that the court does, and we do that respectfully. So we're asking for 5 years in prison, Your Honor. Thank you.
Thank you. Mr. Hallman, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No, Your Honor.
Mr. Hinton, anything else on behalf of the defense?
No, Your Honor.
Mr. Kresge for the State of Ohio.
This is a joint recommendation for 5 years, Your Honor. As was already stated, the defendant was on parole at the time of the offense, stated the amount of days remaining on PRC, and procedurally he was out on bond in the earlier case when the second case was committed. As evident by the age of the cases, defendant has served prior prison term and has been sentenced by this court to prison previously, most recently for aggravated arson in 2021, which was the case he was on parole for. He has 120 days jail time credit in case number 25 CR 997 and 58 days jail time credit in case number 25 CR 751. If the court wishes, I do have additional criminal history, or due to the, as we've discussed in chambers, this is a joint recommendation as we put on the record.
Yeah, that's
Yes.
not necessary.
Thank you, Your Honor.
Mr. Hinton, I do want to get on the record, though, that at this time your client is withdrawing the motions to suppress that were filed in both cases. Is that accurate?
That is correct, Your
And
Honor.
that's what you want to do, correct, Mr. Hallman?
Yes.
Very well, then. This court has considered the particular facts and circumstances of the offenses involved in each of these cases. I did meet with counsel in chambers prior to coming out on the bench initially, and they gave me a summary of what the facts were in each of these cases, in addition to what was put on the record during the plea. And I've taken that into consideration. I've considered what's been said here in court by the parties, the joint recommendation presented. I have some familiarity with Mr. Hallman from the past, and I've taken that into consideration as well. And all of it's considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912. No factors indicate the conduct is more or less serious in 25-751. As for count 2, I will note well, I guess that's a part of the additional finding that makes it, enhances it, the fact that the bullet actually struck the car, that's what makes it 3. So there's nothing indicating to the court that it's more or less serious than the normal conduct that constitutes that offense. As for recidivism factors, the court notes the defendant has a criminal history. He's previously served a prison term. He was on post-release control when he committed both of these offenses. He was out on bond in case 25 CR 751 when he committed the offense in 997. He has failed to comply with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. Under 2913B1, the court again notes the defendant previously served a prison term. In case 997, he committed the offense. Well, this is an F3, right? So there's no findings are necessary for 2913B. So for 751, he previously served a prison term. That's sufficient for that. The court finds in each of these cases that prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to available community control sanctions. Therefore, in case 25 CR 751 will be the sentence of the court. Defendant serve a term in prison of 9 months. He will be given credit for 58 days he's already served. I need to advise you in this case, upon your release, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating the rules for another, this would be 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence. At this time, the court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, and transfer to transitional control. In regards to case 25 CR 997, it's the sentence of the court that on count 2, defendant serve a term in prison of 24 months. Then in the firearm specification, he served a mandatory prison term of 3 years, which shall be served prior to and consecutive by statute to the prison term imposed for the underlying offense, for an overall prison term of 5 years, with the first 3 being mandatory for the firearm specification. There'll be 120 days credit on this case. The prison terms I just imposed in this case shall be served concurrent with the prison term imposed in 25 CR 751. I need to advise you in this case as well, same thing, that upon your release you may be placed on post-release control. It's up to the parole authority to decide that. If you are and you violate, and it could be up to 2 years. If you violate any of the conditions of post-release control, if you are on it, parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I imposed. Any additional prison term imposed in this case for violating post-release controls being imposed as part of the sentence at this time. Defendant's order to pay all costs. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I will dismiss the balance of this indictment. And also, in regards to the first case, 751, I'm going to order the forfeiture of the contraband, and that was set forth in specification. I forgot to note that. So that will be ordered. As for the consecutive findings in 997, there's no special findings that are necessary, as statute requires the firearm specification to be served consecutive to the underlying offense. I also want the entries in each case to reflect that the court adopted the joint recommendation presented by the parties in regards to the sentence that was ultimately imposed. I think that covers everything. Is there anything I've omitted or need to address, Mr. Gretzky?
I don't believe so, Your Honor. Thank you.
Thank you, Your Honor. On the lower case number, we'd ask that bond be released.
Oh, was the bond posted?
It was.
Bond will be released in that
Thank
case.
you.
Yeah. That's right. He was on bond. I only forfeit it when they don't show up, so bond will be released.
Okay. Thank you, Your Honor.
All right. Anything else?
Nothing further.
Thank you.
All right.
All right, we are hearing case 25 CR 1100, State of Ohio versus Ernest A. Fuller Jr. We're here for a scheduled arraignment. Mr. Fuller, have you received a copy of the indictment?
Yes, I did.
When did you get that?
I got it today. I got it yesterday.
When that indictment, you were charged with 2 counts. In count 1, what is alleged here is on or about July 14th, 2025 in Mentor Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to another person by means of a deadly weapon or dangerous ordinance, that being a Taurus PT-22 pistol. That conduct constitutes the offense of felonious assault. It's a felony of the 2nd degree, contrary to and in violation of Revised Code Section 2903.11A2. In addition, there is a firearm specification that alleges the grand jurors further find and specify that Ernest A. Fuller Jr. had a firearm on or about his person or under his control while committing the offense, and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used the firearm to facilitate the offense. In count 2, what is alleged is on or about July 14, 2025 in Mentor Lake County, Ohio, that Ernest A. Fuller Jr., not having been relieved from disability in their operation of law or by legal process, did knowingly acquire, have, carry, or use a firearm or dangerous ordinance, and that Ernest A. Fuller Jr. was under indictment for, has previously been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in a drug of abuse, specifically in the Lake County Court of Common Pleas, case 19 CR 705, being in charge of trafficking in cocaine. That was on September 13th, 2019. As well as Lake County Court of Common Pleas, case number 19 CR 882, being in charge of trafficking in cocaine on September 13th, 2019. That conduct constitutes the offense of having weapons of under disability. It's a felony in the 3rd degree, contrary to and in violation of Revised Code Section 2923.13A3. Mr. Fuller, as to these 2 counts, what is your plea at this time?
Not guilty.
All right, the court will enter a plea of not guilty in each count. Did you care to be heard in the matter of bond, Ms. Tomazik?
Your Honor, Mr. Fuller is currently serving a prison sentence from Judge O'Donnell. He has been offered an own recognizance bond by the prosecutor. At this time, I don't feel the need that we need to talk about bond. Thank you.
Well, bond was set at $175,000, cash surety or 10%. I'll continue that.
Very well. Thank you.
Thank you.
I'll come over to the jail next week and talk to you about it, okay?
Judge will have some questions for
Ms. Wood?
Thank you, Your Honor. We're here for purposes of an in-court arraignment. This is State of Ohio versus Bryant Michael Irby, case number 25 CR 001206. The defendant is present today in court represented by Attorney Bill Watson, and the state previously filed a motion to revoke bond, which was previously granted by this court. Thank you.
Mr. Watson?
Thank you, Your Honor. May it please the court, for purposes of arraignment, my client has received a copy of his indictment. Will waive any 24-hour service, any service defects, waive reading of the indictment. I'd like to enter a plea of not guilty to the charges, and at the appropriate time would like to be heard on bond, Your Honor.
Thank you. Mr. Irby, you received a copy of the indictment?
Yes, sir.
Have you had a chance to look that over at some point?
Yes, sir. I received it Monday.
When did you get it? Monday, you said?
Monday, yes, sir.
You have a right, if you want, to have me read the indictment to you, like I just did with the other.
No
need, you said? No? You don't care for to have me do that?
No.
Okay. Then in regards to these 3 counts, charge of failure to comply with an order or signal of a police officer, felony in the 4th degree, charge of tampering with evidence, a felony in the 3rd degree, and a charge of unauthorized use of a vehicle, a misdemeanor in the 1st degree. What is your plea to those 3 counts?
Not guilty.
I know I have to say not guilty, Your Honor, but I don't want to waste the taxpayers' time and money on this, I really don't. But-
Well, plea of not guilty is going to be entered at this time. What happens, Mr. Irby, is that it gets assigned to a judge at this point. After this arraignment, a judge will be assigned the case, and at that point, your attorney can contact that court and do whatever you want to do at that point. So I'm going to enter a plea of not guilty as to those 3 counts at this point.
I thank you, Your Honor.
You wanted to be heard in the matter of bond, Mr. Watson?
Thank you, Your Honor. May it please the court. Mr. Irby previously was out on bond. It is correct that that bond was revoked. It was alleged that Mr. Irby was violating the rules of his house arrest. What was happening, Your Honor, is my client was going to treatment every day, but he was getting a ride. There was several people in the car, all going to treatment and all going back to where they needed to go. And while they were either going to treatment or going back, apparently the driver was making slight pit stops to pick up food or do something, but Mr. Irby himself was a passenger. He wasn't partaking in any of that. He was simply getting a ride to and from where he lives to treatment and back. So he wasn't violating his rules of house arrest. I mean, I understand that on its face it says he's only to go to and from there directly, but again, he was ride sharing. He was a passenger in a vehicle. Mr. Irby, since his bond's been revoked, has been off his mental health medication. He has a job apparently. He says it's right down the street from here, right here in Painesville. He's been working, going to treatment. He's got a counselor now. Apparently, from Mr. Irby's perspective, he's been doing well in treatment. He had a major relapse, which is the result of this case, but he's trying to get back on his feet. With respect to the fact that he was ride sharing and getting a ride in the car, I would respectfully ask the court to reconsider and reinstating his bond at this time. Thank you, Your Honor.
Give me 1 second, please. I'm confused. You said he's working here in Painesville. All this stuff was in Akron.
No, I was telling the lawyer beforehand, I've been in treatment since February. I've worked for Ruff's RV since '07.
Work for who?
Ruff's RV is on Blackburn Road, but it's neither. I was saying that's my job. I mean, I was telling him about my job, how I was trying to change my life, because my record is horrible, Your Honor.
I'm just saying.
But I'm just saying.
The lawyer just said something about here in Painesville.
Right.
You work living here in Painesville? Got a
No,
job
no,
here
no,
in
no,
Painesville?
no.
What did you say, Mr. Watson?
I apologize, Your Honor. Maybe I misinterpreted him.
Yeah.
I thought he told me he was working here in Painesville. I guess he has a job here in Painesville, but I guess he's not working at this time to correct.
Yeah, but I've been in treatment since the time of this. I've been in treatment since
In
July.
Akron.
Yeah, in Akron. Yes, Your Honor, and everything
And
is.
you live in Akron.
Yeah, it's in the program. It's a strict program. They have urine analysis tests 2 times a week. They have it's a big treatment. It's an intense program. I have 3 mental health counselors. I'm on phase 2 of my contract with them. It's a 6-month-long program, and I'm finally getting myself back together, Your Honor. You have peer support. You have to ride with peer support to everything, meetings, everything. You have to connect with your.
I don't mean to
I'm
say
sorry.
I'm not concerned about the treatment.
Okay, I'm sorry.
But that we're here for a specific purpose here.
Right.
The allegations are that you were on bond and you had certain conditions you were to comply with, and you weren't complying with them in regards to your house arrest. And that's what we're here for right now. So I'm not trying to downplay the treatment or anything like that, because if you're in treatment and it's going well, that's good. But that's not why we're here right now. Give me 1 second, please.
Yes, sir.
You're in a sober living residence right now?
It's treatment, drug treatment. I mean,
Where are you residing?
it's a drug treatment center, but they have separate houses. Whatever phase you go to, you come back to the main center, but you go back to the the house that they place you at, but it's all one big circle, Your Honor. It's all one big circle. And you have support on when they come pick you up in the morning and they stop and let everybody do what they need to do before classes. Class starts, so have different times of the day when the classes get out. So mine starts.
Who's Katie Painter?
That's the head director of Sky Point, Your Honor.
What's the name of it?
Sky Point.
Sky
Point Recovery.
Would you care to be heard on the matter of bond?
Yes, Your Honor. Initially, the state did file a motion to review the conditions of bond, and I attached several emails that I received from the monitoring company as the defendant was on a electronic GPS. I then received additional emails showing that the defendant was making unpermitted stops at different residences, Walmart, Sheetz. I'll also note in the state's motion that I received an email that on September 30th at 3:37 to October 1st at 8:06 that the defendant made another unscheduled exit, and there's a screenshot of the route that was taken. It appears that the GPS follows from the Akron area up to near Chesterland, Cleveland, down through Independence, and back down to Akron. The defendant also put on his bindover transcript his address of 430 North Broadway Street in Green Springs, Ohio. A quick Google search revealed that that appears to be a treatment center in either Seneca or Sandusky counties. Only did the Public Defender's Office file a change of address more recently that alerted the courts and myself that the defendant had changed residential addresses down to Akron. In looking at the bond statute, this is a failure to comply case, as well as a tampering with evidence and an unauthorized use of a motor vehicle. The defendant does have a criminal history as well. He has 6 prior prison numbers here in Ohio, including 2 prior convictions for escape, one in 2021 and one that is from the 1990s. So the state would ask that the defendant's bond remain revoked. However, if this court is inclined to reinstate bond, I would also ask that a no contact order with the victim be ordered. It was not included from the
What victim?
Of the unauthorized use of the motor vehicle. Thank you.
Well, I guess I'm confused because these, I get a stop at Walmart or stop picking something up, but he's up here in Cuyahoga County, he's in Mayfield, he's in nowhere near Akron with these stops. So that's inconsistent with what you're saying. And quite frankly, the condition of bond was house arrest. Didn't give any exceptions for going to treatment or anything like that. Now, again, it's a good thing you're going to treatment, if it's helpful. But you can't just decide on your own. You got to get permission from the courts or whatever if stuff like that's going to happen before you just decide you're going to do things on your own. You want to say something?
Yeah, I didn't have nobody to contact when I got out of phase one. When you see me in Cuyahoga County, I was going to get myself and didn't have no clothes. I submitted myself to treatment with just the clothes that was on my back at the time.
You said you've been in treatment since August.
Yeah, I've been in treatment
All right,
since
well,
August.
this was September 30th. This is just a few weeks ago.
I wasn't in, I mean, if you see any type of other movement, it's either going to other. with
September
meetings or-
30th, you were on Mayfield Road,
Mayfield Road.
Mayfield Heights, Ohio.
That was
Then
probably.
you were on Cleveland and on Woodland Avenue, on Cleveland.
That's the old.
Then you were in Parma.
That's addresses, I mean, that's AANA meets with the peer support that was
There's no reason you should be going. You need to go to Mayfield for AA meeting. And then these are all the same time. These are just
Yeah.
a couple hours apart. All right, it's 6:50. You're on Mayfield Road. At just 40 minutes earlier, you're at a different place in Mayfield Road. A half hour earlier, you're in Cleveland on Woodland Avenue. These are
That's the old.
then,
That's my
then a
old
little
address.
earlier that day, an hour earlier maybe, half hour earlier, you're in Parma. So these aren't different meetings. You don't go to 4 meetings within 2 hours.
No, it was one meeting I went to, Your Honor, and then they took me to go pick up my stuff from 6001 Woodland Avenue.
And why
That
you
was
in
my old
Mayfield?
address.
Why you in Parma?
We went to a meeting up in Parma, and we had picked up another person to take back to Sky Point
No, that's
for
not.
Parma.
That's not. You're not allowed to do that.
Yeah, I did.
You're not allowed to go to AA meetings.
Okay, you're right.
If you're going to go to AA meetings, you go in Akron. They have AA meetings in Akron. You don't have to come up to Mayfield to go to AA meetings or Cleveland.
I'm sorry, Your Honor.
No. You didn't have authorization to do any of this.
But I kept asking for somebody to contact to try to get, after I found out I was on house arrest, because when they hooked
You're
it
put on
up,
house arrest.
when they hooked it up on me, Your Honor, they told me don't leave the state of Ohio. I never knew I was on house arrest until Mr. Mulkey called me and told me I was on house arrest and I couldn't move.
And you weren't
But
in
at
court
that time,
when, you
I
weren't
told
in court
her,
when the judge ordered it?
huh? No,
You weren't-
I was. She just told me GPS monitoring. I came straight here after for bond. When she set the bond on me, I stayed there for a minute in Willoughby, and they brought me here, and I posted bond from here. And they hooked the monitor up here while I was in court. She said GPS monitor. I never knew I was on house arrest at first. I didn't.
No.
I wouldn't lie to you about this, Your Honor.
Why wouldn't
And
you lie to
she-
me about this? Everybody lies to me.
I'm-
Why,
I'm
you're different than
sorry.
everybody else that comes in
But I
here?
mean, Mr. Mulkey said turn myself in Wednesday at 11 o'clock. Sky Point made that possible to turn myself in Wednesday at 11 o'clock. I have no reason to run from this situation.
Sure you do. I mean, and that's, why do you say that? You're facing prison. That's a reason to run for me. I'm not saying you're doing that, but that's a reason to run for me. Oh,
Can I say something, Your Honor? May I say something? This coming. Okay, I'm gonna leave it. alone.
You probably shouldn't. I mean, I know. You probably shouldn't. No, I have a letter here that I think was attached to a motion Mr. Mulkey filed from, who's the gal I asked you about before? The lady
Miss
attorney?
Katie.
I'm going to reinstate your bond.
Thank
You're
you.
on house arrest. You're only allowed to go to treatment and back. She says they're going to take care of the travel, and they're going to make sure you just go to treatment and back. Nowhere else. If we get reports that you're stopping anywhere else, you're going to be back in the jail.
Can I say one other? Just one question.
What?
This is because they have different levels. I'll have her contact whoever, because with every level that you go to, I start to level 3. So that's IOP. I'll go to a different house instead of the one on Arch and Westbrook.
You need to provide to the probation department
Okay.
the locations of the place where your treatment
All
are.
right, thank you.
And you're only going there and back. And she says in her letter that they're able to accommodate you for this. So it's not going to be that you're traveling with others and dropping other people off, stopping to get something at Walmart, picking up clothes anywhere. You're going from the Perkins Road address, that's where you live, right?
Yeah, Perkins.
To wherever the treatment facility is, and you need to let the probation department know the address of those, and nowhere else in between.
Okay.
And if it's anywhere else in between, then bond's being revoked and you're going to be back in jail.
All right, thank you.
And you're further to have no contact with the victim in this case in regards to the count 3 of involving the car. Understand that?
Yes, sir. Yes, Your Honor.
So you need to provide, I want to make sure we're clear, you're on house arrest.
Yes, sir.
You can only be released for purposes of going to treatment. And you need to let the probation department know where those addresses are.
Thank you, Your Honor. Thank you. Thank you for seeing my worth.
All right, is there anything else? Is there anything else for the record?
Electronically monitored house
Yes,
arrest? Okay.
GPS, electronically monitored house arrest with GPS.
Okay, another condition that came over from the Willoughby Municipal Court was
I want all the same. Well, go ahead. Let me hear what it is.
shall not consume any alcohol, drugs, illegal substances, shall not operate a motor vehicle, GPS/electronically monitored house arrest if bond is posted, and shall be subject to random scrutiny.
Yeah, so the no drugs or alcohol is a part of our conditions. Does he sign the bond, that form?
He did, Your Honor.
That's part of ours. I will say no driving. I'm continuing to no driving. And no contact. I think all the other conditions are, we have as a part of the conditions here.
Okay,
All right.
thank you.
Schwartz, anything else?
Nothing further, Your
All
Honor.
right, thank
Will
you.
they hook me up today?
in the state of Ohio versus Daryl Anderson, case number 24 CR 1442. The defendant is present, open court with his attorney, Mr. Mulkey. We are here today for a change of plea. It is the state's understanding and by agreement of the parties that the defendant is going to plead to a lesser included of count 1, attempted abduction, a felony of the 4th degree, and count 2, aggravated possession of drugs, a felony of the 5th degree with the attached forfeiture specification. We would request a pre-sentence report. There is no agreement as to sentencing at this time.
Thank you. Schmolke, does that sound accurate?
It does, Your Honor.
Mr. Anderson, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here at this time?
Yes.
She indicated to the court she believes that your desire to withdraw your previous and or pleas of not guilty and plead guilty to a reduced charge of count 1 being attempted abduction, as well as to count, was it 3? Count 2,
Count 2.
Aggravated possession of drugs. The other 2 counts would get dismissed pursuant to the agreement. We would continue the sentencing to a future day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they think is the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, you need anything repeated or clarified, if you want a moment to talk with your lawyer, ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Let's get started then. How old are you, sir?
39.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a
I
U.S.
have a learning disability, but
Okay, well, are you able? Do you have difficulty reading?
understanding certain things.
You have some difficulty understanding what you read?
Yes.
Well, there's going to come a point in time when I'm going to have you go through some paperwork. Can you assure me that if you're having any difficulty reading it or understanding what it says, you'll ask for help, you'll ask for clarification, whether you ask your lawyer, you can ask me, but you'll do that?
Yes.
All right. Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
Nope.
Not even prescribed medication, nothing?
Prescribed medication.
What has that been?
Zyprexa, Cogentin.
Zyprexa?
It's from the North Coast place I was
Okay.
sentenced.
So Zyprexa, What up?
Cogentin.
say it one more time.
Cogentin
Cogentin.
and propanolol.
Hang on one second. Cogentin, and what was the other one?
Propanolol. I think I'm saying it right.
Your Honor, I do have a list in his report, if you'd like it.
Let me see, please.
The 3 are in the bottom paragraph.
Yeah.
Cogentin. Is there anything else aside from those 3?
There was another one. It's called the Vega. It's a shot that they give me once a month. But since I've been in the county from the treatment center or from North Coast, they haven't gave that to me. So, because somebody's supposed to give me a shot. It's called
I see it in Vega.
in Vega.
When did you get back from the
I
hospital?
came back on the 7th
Of October?
of October.
When did you last have a shot?
I'm due for it.
Or when did you last have it?
Last month.
All right, so any of these medications that you've taken, do any of them affect your ability to understand or appreciate where you are, what's going on around you, anything like that?
No, they help me.
Help you? Okay. Now, you would have been served with a copy of this indictment previously. That's the document that sets forth the specific charge you're accused of committing. Do you remember getting that?
Yes.
Did you have the chance at some point to review that?
Yes.
Now, in that indictment, you are charged with 4 counts. You're pleading guilty to 2 of them. Well, 2 charges. One's a lesser charge of the one. I'm going to go over those with you now to make sure you understand them. If you have any questions, make sure you ask. But in count 1, what is alleged here? This is not what you're pleading guilty to. What's alleged is on or about December 11, 2024 in Painesville Lake County, Ohio, that you did without privilege to do so knowingly by force or threat restrain the liberty of an individual with initials PM under circumstances which create a risk of physical harm to PM or placing him in fear. That conduct constitutes the offense of abduction. It's a felony of the 3rd degree. Now, that's what you're charged with. That's not what you're pleading guilty to. That's what you're charged with. Do you understand what you are charged with?
Yes.
Any questions about it?
No.
Now, for purposes of the plea today, the state has agreed to amend this count to what's called attempted abduction. And what that means is that it's alleging that you engaged in conduct that, if successful, would have resulted in the commission of the offense that I just read to you. And the significance of that is it reduces it from a felony of the 3rd degree to a felony of the 4th degree, which is less serious. So do you understand the difference between what you're charged with and what you're pleading guilty to?
Yes, Your Honor.
Any questions for me about that?
No.
Now, count 2, what's alleged here and what you're admitting to, is on or about December 11, 2024 in Painesville Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance. The amount involved was less than the bulk amount. It was less than 3 grams. What's 3 grams? Is that
Bulk for nothing.
So that conduct constitutes the offense of aggravated possession of drugs. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 2?
Yes.
Any questions for me?
No.
Now, this charge also carries with it what we call forfeiture specification, which alleges to the commission of the offense you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal in and of itself, whereas an instrumentality is some type of property. There may not be anything illegal about it in itself, but it's being used in an illegal manner or to facilitate a crime. You can't use it for that purpose. And here it's alleged there's the methamphetamine, of course, along with a pocket knife and all the packaging. The whole point of this is that you forfeit any ownership interest you have in that property. It doesn't increase any potential penalty you face, but you forfeit your ownership interest. Do you understand that?
Yes.
Any questions about it?
No.
Now, there are 2 other counts of this indictment that are here that are to be dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about those 2 charges?
No.
Well, now, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to a trial. Now, the trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial. That would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each specific charge. You understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Having the burden of proof means that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all the charges. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak about this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means It's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I read to you beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that will come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You'd call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's solely your choice, what that really means then is that nobody else can force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness, make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of any of these charges, excuse me, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes.
Very well, then. Do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you will first off be found guilty by the court, and then you will subsequently, on a later day, another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty in the count one, the lesser included offense of count one. It's a felony of the fourth degree. It's punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, count two is a felony of the fifth degree. That's punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, since there are two separate cases here, if I impose a prison term, I impose it on each count. Not two separate cases. There's two separate counts you're pleading guilty to. And if a prison term was imposed, I'd impose it on each count. And then as a judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You serve them at the same time together. Consecutive means one after the other. You serve the prison term in that first count, finish it, then serve the prison term in the next count. So you understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum prison term of 30 months or 2.5 years in prison. You understand that?
Yes.
Now, are you currently on probation or post-release control to any of the courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you're on post-release control and you ever violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
All right, now aside from the possible prison sentence, I just explained to you, there's other penalties or sanctions that could be imposed. You could be fined, and the lesser included offense of count 1, the attempted abduction, that carries with it a possible fine of up to $5,000. The drug charge in count 2 carries with it a possible fine of up to $2,500. So together, that's a maximum possible fine of $7,500. You could also be ordered to pay court costs. You can also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand all that?
Yes.
You could also be ordered to pay restitution if that's applicable for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes.
The drug charge also carries with it a possible license suspension of up to 5 years. Do you understand that?
Yes.
And lastly, in regards to that forfeiture specification I explained to you a little bit ago, any right, title, or interest you have in the property will be forfeited in the state of Ohio. Do you understand that?
Yes.
All right, now a few moments ago I explained the possible prison sentence. I did use the word possible because prison is not mandatory or required with these charges. You are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes.
Now, just because you're eligible doesn't mean it's automatic that you're going to get it. It means I'll consider that if that's what you're requesting. I'll look at all the information presented, then I'll make the decision I believe is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years of supervision, and as the judge at the discretion order a wide variety of rules and conditions for you to follow. One of the conditions could be in order that you serve a term in jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you're on probation and you violate the conditions of your supervision, we'll have a hearing to see if you're a probation violator. If it's determined that you are, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you. Or I could terminate or end your probation and send you to prison if I did that at that point. Again, it could be up to a total of 30 months in prison, which would also be consecutive or could also be consecutive to any other prison sentence you may be serving at that case or at that time for some other case, or that you're being sentenced to if you pick up any new charges. Do you understand that?
Yes.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider, your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right. Well, do you have any questions at all about these potential penalties you face that we just discussed?
No, Your Honor.
You understand all the possible consequences? Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer and have him review everything with you and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right then. Mr. Anderson, any questions for me at this time regarding anything we've talked about here?
No.
Do you need any more time to speak with your lawyer?
No.
All right, so what we're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would be at a trial if we had a trial. I want you to listen to her because I'm going to have some questions for you about that, all right?
Okay.
Ms. Contour?
Thank you, Your Honor. The evidence would have shown that on December 11th of 2024 in Lake County, state of Ohio, the victim in this case was completing his route. He is a U.S. postal worker. The defendant approached him. He came up very close to him. The defendant did have his hood up and had both of his hands in his pocket. He began directing the victim to behind one of the houses with his hand in his pocket. The victim believed that he was either being robbed or that the defendant did have a firearm. He said that he felt threatened and that he could not leave. When the defendant was arrested in this matter, he was searched and there was suspected narcotics found on his person. Those were sent to the Lake County Crime Lab, confirmed to be methamphetamine, the amount being less than 3 grams or the bulk amount.
Mr. Anderson, were you able to hear what the prosecutor just had to say regarding what she believes the facts would show if we had a trial?
Yes.
What, if anything, did you say about those facts as she presented them? Are they true? Did you do what she said?
Yes.
Very well, then, regarding the lesser included offense of count 1 being attempted abduction, a felony of the 4th degree, what is your plea to that count?
Guilty.
Regarding count 2, charging with aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything we've just discussed. Before I can accept your plea, I need to make sure you understand the document that you signed it here in court. Now, my understanding is before I came out here, you had a chance to review the document with your lawyer. Is that correct?
Yes.
And this is the paperwork I was talking about earlier. I need to make sure you understand this document. Mr. Mulkey, did you review this with Mr. Anderson?
I did, Your Honor.
Did you read it to him?
Not word for word, but I went over all the points of it with him. I didn't read every single word to him. He indicated an understanding. I summarized it in great detail for him, and after each part, I asked him if he had any questions.
Did you read it, Mr. Anderson?
Yes.
Did you understand what you were reading?
Yes.
And your attorney helped you out as well?
Yeah.
Do you have any questions for me about what it says?
No.
You understand what it says?
Yeah.
It also appears you signed the document. Did you sign it?
Yep.
Mr. Mulkey, you witnessed that?
I did.
Ms. Contour, you
I
too?
did.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Finding the defendant guilty of the lesser included offense of count 1 being attempted abduction, a felony of the 4th degree in violation of 292302, as well as 2905.02A2. And count 2, aggravated possession of drugs, felony of the 5th degree in violation of 292511 with the forfeiture specification. Counts 3 and 4 will get dismissed at sentencing, but I'm going to defer sentencing, order a pre-sentence report investigation, psychological evaluation, drug and alcohol evaluation, and a victim impact statement. Bond will be continued. Is there anything else for the record at this time, Ms. Contour?
Nothing further, Your Honor.
Mr. Mulkey?
Nothing, Your Honor.
Thank you.
All rise.